SJC-13298, the Judge Rotenberg Educational Center, Inc., and others, v. Commissioners of the Department of Developmental Services, and another.
Okay. Attorney Casey.
Good morning, Your Honors, and may it please the Court. Tim Casey, Assistant Attorney General, on behalf of the appellants. Your Honors, Massachusetts is usually at the forefront of our nation in terms of recognizing individual rights, honoring the inherent dignity of every person, and protecting the most vulnerable among us. This court is often central to that important role for our state. But this case is about one way in which Massachusetts is an outlier in the wrong direction. We are the only state in the Union where painful electric shock is used on our most vulnerable and powerless citizens, those with intellectual or developmental disability, or IDD.
Attorney Casey, we have to decide whether or not the purpose of the settlement agreement has been fulfilled under the RUFO standard. Could you tell me in one sentence or two sentences what, as you see it, is the purpose of the settlement agreement?
The purpose of the settlement agreement, Your Honor, is to restore JRC's license, to allow it to resume intaking patients, and to ensure that DDS and state regulators give equal consideration to JRC along with other providers for the placement of individuals who need care.
The lawsuit was brought in part to vindicate the civil rights of the patients to treatment, right? Is that part of the purpose?
It was brought based on a claim that DDS's predecessors had unlawfully attempted to cease treatment at JRC.
Right. Is that part of the settlement agreement as well?
It is, insofar as the primary purpose, as stated in the preamble of the decree, is to resolve the discrete litigation between the parties. And I would note, in terms of fulfillment of that purpose, Your Honor, that DDS and its predecessors have continuously licensed JRC. It has remained open since the consent decree. DDS has doubled its funding to JRC since 2005. From 2005 to 2015, it went from $5 million to $10 million. The number of patients who are DDS funded has increased during that same time. So, JRC has remained open throughout that time. It's remained licensed. So DDS has emphatically fulfilled the purpose of the decree.
So what are you looking for us to do?
We are looking for the court, we're asking the court to reverse the decision below and to entirely vacate the consent decree.
And our review is for abuse of discretion.
Correct.
Okay, and so how, given all the facts that you've just articulated and all the facts that I'm sure you marshaled before the probate court, how is this an abuse of discretion?
It is an abuse of discretion, Your Honor, for a number of reasons. First of all, an error of law, of course, is an abuse of discretion, and there are a number of errors in the probate court's decision that we identify in our briefs and we'll talk about today that warrant reversal of the probate court's order. There is also the case law about consent decrees and modification of them from cases like Rufo and Horn against Flores talk about how when a trial court is presented with significant changed circumstances, it is an abuse of discretion for the court not to modify or vacate the consent decree. And here our position is that we did present the probate court with really overwhelming evidence of changed circumstances, both of fact and of law.
And before you finish after you finish on your error of law, can you tell me whether you are challenging any of our findings, which findings you're challenging? But you can finish which errors of law you have.
Sure. We challenge a number of the findings, but I would say, first of all, there were, and more centrally, there were legal errors in the court's decision. There were structural errors, particularly with regard to changed circumstances, in how the probate court assessed the standard of care and changed circumstances that led to reversible legal error in its conclusions regarding the standard of care. And also, a number of the findings are based, particularly with respect to bad faith, are based on documentary evidence, which this court can review de novo itself. Even though the ultimate standard is for abuse of discretion, this court is in as good a position.
All right, so now you've set forth the categories of errors. What specifically amounts to an abuse of discretion?
So to begin with, it violates the public interest and the separation of powers for this decree, particularly as it has been used by JRC and interpreted and enforced by the probate court to continue for the consent decree to remain in effect.
So when does that trigger? Is there a time frame where there's a separation of powers issue when a consent decree? What is that time?
Well, certainly, if not before then by the time DDS promulgated its 2011 regulation that prospectively banned level 3 aversives, for JRC to defy that regulation and to continue to try to place new individuals on level 3 aversive plans, and for the probate court to ratify and endorse that view of the 2011 regulation, that it was invalid because it unduly interfered with the probate court's substituted judgment authority.
So DDS issues a regulation, and that causes a separation of powers problem if the consent decree is continued to be enforced?
Yes.
And what's their legal authority for that proposition,
The
other than Article 30?
legal authority for, I'm sorry, are you talking about the probate court's assertion of legal authority?
No, for the proposition that as soon as DDS issued this regulation, it caused the continued enforcement of the consent decree to be a separation of powers problem.
Yes.
What is the legal authority for that?
Well, there's,
That can't, I mean, I get there are all kinds of problems with this, but that can't be right, because in 2010, the judge makes findings in 2010, again, 2010 is a long time ago, ancient history in this world, but in 2010, the judge finds that you doctored, not you, but your client DDS doctored evidence. That's 2010, and she's got support for that. How and somebody else manipulate the documents. And then in 2011, you immediately passed this regulation. In 2011, you're in trouble, but I'm not sure that's the end of the discussion, but that regulation that's based on doctored evidence has to be a problem for you.
Your
Now,
Honor.
that doesn't end my concerns about the judge's decision, but you're at your weakest point in 2010 and 11, aren't you?
no, Your Honor. We emphatically reject the notion that this was doctored evidence.
I mean,
This
she
is-
makes,
and if
she
I could,
makes
Your Honor,
direct,
this
she
is a-
makes direct findings on that.
Makes
that
direct-
how manipulates the documents. Now, again, in 2013, there's another certification process, and it doesn't seem like you do anything wrong in 2013, and nor in 2016. And we're now in 2023. That's a different issue. But I just don't see how you can, if you're focused on 2010 and 2011, you've got a problem, don't you?
No, Your Honor. We do think this is fundamental legal error that is reversible. The probate court's conclusion of bad faith rested on the redlining of two documents. One, the Hamad report in 2008 had no role.
Forget about the Hamad report. Let's look at the second report.
Yep.
The second report, the actual people doing the certification find that you're getting a one-year, the center is going to get a one-year certificate and there's substantial compliance. Howe rewrites that and says they're not in, I mean, they have work to do and gives them 14 days, or something. That's a big change, isn't it?
Your Honor, I urge the court to review each of the drafts of the 2010 certification. What you will find is that the certification team, and by the way, you're going to hear from the other side that supposedly the certification team was not independent. There is no legal requirement, and this was a feature of the probate court's decision as well. There is no legal requirement that the certification team be independent. By regulation, they function as the authorized department representative.
But the consent decree requires DDS to act in good faith. Again, I'm going to be asking all kinds of questions to them about what relevancy 2010 has in 2023. But in 2010, there are fact findings by the judge that you manipulated the documents, and you passed a regulation shortly thereafter. So I just feel like you're on weak ground then, on bad faith.
Well, Your Honor, if I could, I'd like to spend a little time on this 2010 certification report, because we emphatically do not believe that this was doctoring or that this was indicative of bad faith. And we do think the probate court committed legal reversible error in its characterization and its findings regarding the certification report. The certification team issued a draft, sent it to DDS, that contained numerous findings regarding the deficiencies at JRC with respect to its Level 3 program, many of which had been extant since before the end of the receivership in 2006.
Again, the focus of the case, it's a heart-wrenching case, because the focus of the case is, can you use this electric, the GED-4? Is it inappropriate to use it on any patients or certain patients? That's what this case is about, right? It's not about sort of the bigger picture at this point, because DDS wants to eliminate the use of the GED-4, and the center wants to continue using the GED-4, right? That's what this case is about, what we have to decide, right? Whether it's appropriate to use that for this limited category of patients, right? Is it the least restrictive means of treating these people?
This court has to decide whether the various bases that we've asserted.
That's the center of the case, right?
It is a critical part of this. It is about whether changes in law and fact warrant vacating a 36-year-old consent decree that by its terms was supposed to last for 1 year.
Does that change the standard of review, by the way? That's the one thing because you have a very uphill battle on abuse of discretion, if that's the standard, but this consent decree was supposed to end in 6 months. Did the parties agree to the extension? When Judge Rotenberg extended this, was that consented to, or was that just unilaterally imposed?
Your Honor, I don't know the answer to that. What I know was that at the time, JRC's license had not been fully restored yet. And so Judge Rotenberg relied upon that fact to extend.
But I'm just trying to understand, though, because we have cases, I'm not aware of cases on the standard review for extending a consent decree that was supposed to end. Does that have a different standard of review than, that would help you a lot if that were the case. But I just don't know, no one cites cases on like this where the consent decree had a firm deadline.
Your Honor, we do cite some cases, and I'm sorry I don't have the names of them at the tip of my tongue, but we cite some cases in our brief where the consent decree itself was time limited, and that was a factor that led the court to terminate the consent decree, especially after the passage of time. And
Shift the burden of proof on.
I don't know that it leads the court to apply a different standard of review, but it does lead courts to conclude that that standard has been met, as we emphatically believe here, for 3 reasons: the public interest, the significant change in both fact and law, and the fulfillment in good faith of the purposes of the consent decree.
When you started out, you were about to sound like excoriate the whole concept of the use of the GED devices as it relates to the standard of care. And in your brief, you talk about a public duty as to the highest standard of care. My question, big picture, is this has been around, this debate's been going on forever. I can remember how heated the debate was in the mid-1990s as far as the use of level 3 or level 4. Are we talking about the higher standard of care? I mean, I have the concerns that 50 years, when you look back, people are going to say this was bloodletting. On the other hand, I feel like these families and these people providing treatment to people who really need it should have whatever hope they can have if this falls within the standard of care, not the highest standard of care as you reference in your brief. Help me understand how that concern relates to the consent decree.
Your Honor, we do not talk about, in our view, talk about the standard of care in terms of the highest or the best standard, although DDS's regulations do talk about the least restrictive, effective form of treatment. But let me, in answer to the second part of your question, let me say this. DDS would not have brought this motion to vacate the consent decree. We wouldn't have spent 3 years litigating in the trial court over this, and we wouldn't have spent 2 years litigating this appeal if we did not believe, if DDS did not believe, that there is a more effective and more humane way to treat
Right, and now
individuals
that's
with
what I
IBD.
was reading that the judge said, though, in her findings and her conclusions, that she didn't find that you really offered an alternative, a specific alternative,
Yes, Your Honor, and we believe that was legal error, legal structural error.
because you did offer those alternatives to her?
We did. There was voluminous expert testimony about the standard of care.
How's that legal error?
Yeah.
Because what the probate court did was it said, since you cannot prove DDS, that you could more effectively treat every JRC resident with these alternative forms of treatment, which are the standard of care, instead of with skin shock, you have failed to show a change in the standard of care.
But how could, well, never
That's
mind.
precisely, Your Honor.
It's-
How could we? How could we, when patients at JRC have been treated there for decades?
Well, and there are no long-term studies, is that true?
Absolutely. There is no long-term studies demonstrating the efficacy of skin shock. The studies do not address side effects.
She says, she makes direct findings that there isn't a scientific consensus to get rid of this treatment for the most troubled, self-injuring patients, right? She makes that very finding. She refers to this ABA textbook. She also refers to testimony from 2 or 3 of these physicians, right? How do we find that's error of law? Because she weighs the different, you put in 3 experts who say this is inappropriate, beyond the standard, but then she relies on testimony from 3 different trained psychiatrists, right, that say the opposite, that in these extreme situations where nothing else has worked, we still want to preserve this option. Doesn't she say that?
Answer in terms of error of law or error of fact.
Well, it's both, Your Honor. To clarify, we think that even under a clearly erroneous or abuse of discretion standard, that is an erroneous, reversible conclusion. We do think that there are structural errors in the way she assessed the factual evidence that led to her erroneous conclusion regarding the standard of care.
But could you be more specific? What is the structural error? She held you to too high of a standard?
Yes.
Okay,
Yes.
because it was impossible to prove.
It was impossible to prove that we could more effectively, that DDS could more effectively treat patients with psychotropic medication, where at JRC, because
And what would be the better standard, the correct standard?
the
in your
correct
estimation?
standard would be, first of all, whether there's a significant change in circumstances, and to apply the actual definition of the standard of care, which is the standard employed by the average practitioner. The evidence at the trial.
They're not average patients, I guess.
No, they're not. They're not. But
So I don't understand how your standard fits in.
Well, what we did show at trial, Your Honor, was that every other provider in the country and the world treats the most difficult patients with the most difficult self-injurious and assaultive behavior without the use of electric shock. They do it in a host of ways, first of all, by doing a comprehensive assessment of the patient, by using a team approach.
Right, but now you're arguing the facts, and on that, I think you lose. What's more interesting to me is that you suggest that the judge has made a legal error, and I still am trying to capture that. It's that she held you to a higher bar than you feel you should have been.
Yes.
But she didn't make that finding. She made a finding, right, that you haven't established that there's a consensus in the scientific community that this should be eliminated for the most troubled, self-injuring patients. That's her finding, isn't it? You failed she said there's bad faith based on a 2010 doctoring of evidence, and that you have not shown a scientific consensus because of there's conflicting expert testimony on how to treat the most troubled, self-injuring patients. Those are her essential findings, aren't they? They weren't, I mean, she's got a lot of other findings, but those are the two findings she says you didn't meet in the last couple of pages of her decision, right?
Right, and we think those are both erroneous as a matter of,
But that's clearly, meaning that we have to find those are clearly erroneous factual findings, right?
Your Honor, on bad faith, we think that the finding of bad faith is based almost entirely on documentary evidence that this court can review itself. And I would, if I may, come back to that in a minute, because
Before you leave that, though, because I don't know what we're going to do. When we read all this expert testimony, which again is totally dated, we're going to be deciding something. I have no idea whether there's now a scientific consensus that this is bad or good. This was, when did, the hearing took place in 2015, is that right?
And 16, Your Honor.
And then we don't get a decision until 2018. It's now 2023. I mean,
So the standard of care is what year that we're looking at?
Well, Your Honor, we acknowledge that you're reviewing the probates court's decision at the time it was made, based on the record before it.
But that's not what anyone cares about. What people care about is what's the standard of care today? What are these patients going through
Well-
today? What should this be an available in the toolbox for those who have hope? Or is it just so antiquated it doesn't make sense? I don't know how you calibrate that in 2015, 2012, 2011, or when the memo was written. I'm only interested in the here and now with real people and real hope and real concern. Deviates from the standard of care.
and could we add to that, not only is this antiquated, but this DDS is the DDS that was in 2010 and 11. That's 2 governors ago. Are any of these people who are involved in this even working at DDS anymore? I mean, Howe doesn't work at DDS, right? The person who doctored McGregor doesn't work at DDS, right? So we're analyzing a DDS that's 13 years old. The last time there was misconduct in DDS was in 2010, right? This decision is based on the fact that they manipulated the evidence in 2010. It's 2023.
Well, Your Honor, obviously we
What are we
disagree that it was.
supposed to do with that?
Well, let me tell you what the receiver did in 2003 when the receiver recommended the end of the receivership. The receiver said, the people who are now in charge of DDS's predecessor are no longer the people who were involved in the 80s and the 90s. Personnel have changed, regulations have changed. The agency should not be forever subject to judicial
May I ask you one
tutelage.
question right there? Have the patients changed? Are there new patients, additional patients, or are we still dealing with the same subset of, same patients?
What's supposed to happen, mostly the same patients, Your Honor. And the reason is because under the 2011 regulation from DDS, it is only supposed to be persons who are legacy patients who had a level 3 plan as of 2011 who may continue to have a level 3
So
plan.
why do you say mostly?
Because in 2015, at the time of the trial, there were 63 patients with level 3 plans. 64, and now there are 53. But we do identify in our brief,
Nobody additional.
there's not supposed to be anyone additional. JRC has relied upon the consent decree to try to place new people and has successfully done so on, as far as we're aware, 2 occasions in defiance of DDS's regulation.
So the regulation permits this kind of treatment for existing patients.
For legacy patients who had them in effect as of 2011.
And so in light of that, how is this treatment not sort of outside of all the bounds of what is the standard of care if the regulation in fact permits it?
Your Honor, DDS made the decision it did in 2011 to regulate prospectively based on the consent decree.
Yeah, but prospectively, after 2011, you're allowing the legacy patients to continue to use this treatment. And I'm questioning whether, given that your position is that this is outside the standard of care, doesn't that regulation present a problem for you from a factual perspective?
No, Your Honor. We think that if DDS in 2011 had tried to regulate retrospectively in addition to prospectively, JRC would undoubtedly have said that that was a violation of the consent
So
decree.
basically, once you're free from the shackles of the agreement, you're going to regulate it out.
Your Honor, no decision has been made in that regard. But I do want to say this. That would be DDS's prerogative to do so.
But that's the
It would have to.
that's the Article 30 issue, right? Because as I read the SJC's contempt decision in the settlement agreement, it gives lip service to separation of powers and says, of course, there's an Article 30 issue were we to take over the executive. But then, as I read it, every time there's a regulation, when the regulation is found to be enacted in bad faith, then you basically forfeit your Article 30 rights.
Your Honor, what I would say about any potential future regulation is this. DDS would have to go through an entirely new rulemaking process under Chapter 30A, right of notice and comment from JRC and every other interested party. If JRC felt that the regulation was improper, they would be free to seek judicial review.
But that's not before, I mean, what's before us is whether the judge made a mistake in 2018 based upon the record in front of her in denying the motion to vacate, correct?
Correct.
Everything that happened post-2018 isn't before us.
That is true, Your Honor. There are some things, as you know, that we think are judicially noticeable. Justice Lowy, I think you asked about the standard of care now. I would direct the court to the amicus briefs filed by the ARC of Massachusetts and the American Pediatrics Association that talk about.
How can we use that as the standard of care when the judge made a finding about standard of care in lack of a consensus in 2018? Then you want us to basically look at the amici brief and say the standard of care changed and the judge was wrong based upon our review of the standard of care?
No, to be clear, I'm not asking the court to rely on some new body of evidence that renders a different conclusion about the standard of care. We think that the amicus briefs identify additional evidence that is simply confirmatory of what we demonstrated at trial, which is that the overwhelming weight of authority is that this treatment is inconsistent with the standard of care.
I think the first question Justice Wendland asked you, or the second question, is how do we get behind or go beyond the judge's finding that there's no consensus, where she heard 40 days of testimony and heard from all the experts, and you want us to say that was a clearly erroneous finding? And I'm not so sure about the whole standard at all as far as what's a consensus mean. Does it mean one doctor, two doctors, 3, 7? I don't know what that means.
Well, along those lines, Your Honor, I think one error that the judge made was that she effectively required unanimity in the standard of care. She said the fact that this form of treatment is banned and not used anywhere else in the country, or as far as we know the world, is not per se evidence of the standard of care. It is hard.
That's not per se incorrect, is it?
Well,
Because the overall standard she's looking at is the Rufo standard, is whether the facts have changed, correct?
yes.
And so the facts you say changed are that we have new treatments.
Yes.
But how are they different from the treatments that were inadequate before? How have they so improved?
Your Honor, as the court is no doubt aware, our nation has a shameful history in how it treated in the past those with intellectual or developmental disabilities, often placing them in large facilities, treating them with large, high doses of antipsychotic medicines. In 1987, when the decree entered after 4 days of testimony at a preliminary injunction hearing, there may have been an argument that compared to the alternatives, this is a reasonable form of treatment. Now, everything that has changed, the evidence at trial was that there has been a sea change in the way.
But is there evidence that shows what that sea change would look like on people who have had this treatment for 10 years, 20 years. You've got evidence to show that you could switch them over with no problem, and they could just go on these brand-new medications, and everything would be just as good.
Your Honor, this is a good point for me to mention and to urge the court to watch the videos that are in evidence.
But didn't she makes the exact opposite finding, though. She says some of these patients had been on a whole protocol of psychotropic medicine, and it hadn't worked. And then this had been successful for some of these patients and actually those patients actually testified before her. So again, how do we deal with that this place is alone, you're right, but it also has a track record that she was presented with and she found credible that it's been successful for people who failed under these medicines. So what do we do with that?
Your Honor, we think the testimony was substantial at the trial that, yes, many people come to JRC over-medicated. They may have been misdiagnosed. They may have been improperly treated by other facilities and other clinicians.
Some of the best facilities in the world, right? Some of these people had come from the best teaching hospitals around the country, McLean, top places in New York, right? It's not as if she's presented with that evidence, right?
Your Honor, they have been treated at other facilities, and they came to JRC and were treated according to JRC's treatment philosophy. But we think that the testimony that was developed at the trial was that this is not how patients can and should be treated in 2015, 2016. And it's certainly not how they should be treated in 2023, where they are assessed for underlying medical conditions that may be...
But how do we do the last part? Because again, Justice Lowy's question is the same as mine, which is, it's 2023. We have, I mean, for example, the briefs talk about half the states have banned this. Is that still the number, or is, the FDA tried to ban the FDA banned the device, but then it was overturned by the DC Circuit. Is this a case that we should get current information on and send back to the probate judge so that we actually do this based on current science and define the issues more clearly and get up-to-date information on all of this? Because say we bless this. In 2016, the judge, her findings we can't find clearly. I take it we're going to have the same exact case brought in probate court 2 months from now based on 2023 evidence, right?
Your Honor, if the evidence that was presented in 2015 and 16 is not enough to vacate this 36-year-old consent decree, then it is hard to imagine what would be sufficient, both in terms of standard of care.
To be honest, I find that really hard to believe, because in 2010, I know you want to run away from this, but in 2010, right before the regulation is changed, there's evidence of sort of a political gathering followed by a rewriting of a report. But we're now in 2023 with a totally different DDS that has demonstrated no evidence of bad faith that's been presented after 2010. I'm talking about 2013 and 2016. So I'm just not sure it is the same case.
Your Honor, we urge the court not to remand the case to the probate court for further findings or to consider new evidence. And the reason is because it took 5 years from the time we filed the motion to vacate the consent decree in 2013 until it was decided in 2018.
Well, isn't that just the nature of a consent decree? It's going to keep going until you challenge it and get it overturned, right? I mean, so this is just going to be a back and forth unless we decide to vacate it right now.
Well, Your Honor, if this is not a good enough record to vacate the consent decree, then it is hard to imagine what would be good enough. And sending it back to the probate court to hear And again, the new evidence that I talked about in the amicus briefs, that there's nothing new there. It's simply an accumulation, a
You're saying
confirmation.
it confirms.
It confirms.
The evidence that you already presented, that the probate court rejected, and we're supposed to review it, either for an abuse of discretion if we find it's a factual matter, or, as you say, the probate court judge held you to a too high a standard, which would be a legal error.
Correct.
Okay.
Even if we find that there was bad faith in 2010, right before the 2011 regulation, which you want us to enforce, and so there's the exact pattern that occurred in 87 and 95 and 2010. But that may have all disappeared now. DDS may be a new agency that's not so result-oriented that it will change the documents to get the result it wants. You don't want that possibility to develop that.
Well, Your Honor, respectfully, I disagree with the idea that we're running from what happened in 2010. We
Well,
absolutely
you
believe.
can run from it or you can accept it, but she has made fact findings that the Assistant Secretary of Health and Human Services changed the report that gave them a one-year certification and also changed the report that said they were in substantial compliance right after a meeting that occurred with, higher level people in the governor's office at the time. So it's going to be tough to find that's clearly erroneous.
Your Honor, based on the documentary evidence, which this court can review de novo, we feel very strongly that what happened in 2010 with respect to the certification report is the certification team playing its role in assessing the deficiencies and the conditions on renewed compliance. It was Dr. Lewandowski of the certification team who first suggested a corrective action plan, and then the commissioner of DDS exercising her clear regulatory authority
She
to.
finds him incredible. She finds, again, we can look at the documents, but you're running against a lot of fact-finding about what happened in 2010.
Okay, do we have any other questions? No. Thank you very much.
Thank you, Your Honors.
Attorney Stern.
Good morning. I'm Max Stern, and I represent the class of patients and their parents. Let me say there are 5 facts, all supported by the court below, which themselves make this dismissal of this appeal a dispositive matter. The 5 are these. 1, the evidence was very clear that no other treatment has worked for this very small and endangered group of patients who were previously tried on everything else. Secondly, the decree requires that aversives be a last resort, and that is exactly what the judges repeatedly have found. Furthermore, the alternatives, we just heard that there's been a sea change. Not so. The alternatives to this particular treatment for this very small cohort of patients have not changed. So-called PBS, that's been around forever. That's using positive methods in order to improve behavior. As far as the pharmaceuticals are concerned, the evidence was that it hasn't worked, that it hasn't changed. They had the person who was in charge of testing for the FDA for the so-called miracle drugs, Risperdal and Abilify, and he testified that they were a big disappointment. They were not better than a placebo. So, moreover, the drugs have their own downsides. So, the science has not really changed, and it certainly has not changed. There is no alternative for this small group of patients. That's fact number one. Fact number two, the GED skin shock treatment at JRC has in fact been effective for this population. DDS's own experts have conceded that it quickly reduces these problematic behaviors to zero or near zero, and that it's been very effective in many, many cases. And the statistics show that as well. Judge Field referred to a study of 189 patients, which were all the patients that had gotten this treatment from the year 2000 on, and the statistics showed that from the average.
Can I ask some factual, because she makes a lot of factual findings that I'm not sure I can square with this. So they don't provide psychotropic. They haven't reviewed a number of these patients for 5 or 10 years, whether they could benefit from psychotropic medicine, right? It's against the philosophy of the center, right? So use of psychotropic meds.
You know, there are persons who are on drugs. It's not the majority of
But she
them.
says that I can't remember, there's fact finding here that says there hasn't been any attempt to use an alternative for 5 or 10 years for a number of these patients, right? And then she also, I mean, the consent decree requires you can only use the GED, although the GED actually happens after the consent. You can only use level 3s as the least restrictive. If anything else works, you shouldn't be using level 3s, right? That's fair statement.
Right, that's
But
right.
then she
It's a
says that-
last resort.
But she says
remedy.
then there's been no look at psychotropics for at least 5 or 10 years for a lot of these patients. And even in her conclusions, I read them as suggesting that she thinks some of these patients may very well benefit from this. So what do we do with those findings? They haven't looked for 5 or 10 years for some of these people being regularly shocked about whether a psychotropic meds could work. And there's evidence before that there are all kinds of new psychotropic meds. So what do we do with those findings? Because again, if you are shocking people that something else is better than, if something else is better, you shouldn't be giving them the GED-4, right?
That's
Is that
right.
a new,
That's
is that
right,
a
but there is
change
no-
in circumstances that would justify lifting this?
There is no evidence that these new drugs are better.
But she
or
said,
that
but
they
how
work.
do we know that when she says you don't consider it for 5 or 10 years, and the scientific community has got new drugs that may work on some of these people, right?
Let me get right to what I think is the most critical
Well,
legal.
don't duck the question,
No,
because we're struggling
this
with
is
it.
directly to your question, Your Honor, which is the way the consent decree works. Because the consent decree is a method of total individualized medicine. That's what happens. It comes up, first of all, that when you start, there is a very thorough vetting of this patient, the patient's history, everything that the patient was on before, all the circumstances of the patient, and it goes through all kinds of committees and analyses and so forth, and then ultimately gets to the judge in the substantive judgment proceeding. And in that case, there's an adversary hearing, there are experts, there can be an expert on both
That's to
sides.
start the process, right?
That's the start, and then.
But then, don't you have to, I mean, we've got new meds on the market. We have new treatment protocols, but there hasn't been any reconsideration of this for 5 or 10 years and maybe even longer, right? I mean, are some of these people, and then we've got fact findings that say it sometimes takes 5 or 7 years to to lower the amount of time this works. I mean, we've got, you know, that some of these people are being shocked for 5 or 7 years before you start seeing results, right?
Well,
That's a fact finding in here, right?
no, I think there was a fact finding that sometimes there's a regression, and sometimes it will go up, but it can come down again. But if I can get to the
But can
point,
you ask, but so again, I understand the judge approves it initially, but then we can go on for years and years without a review of this, in the sense that a review of whether a psychotropic medicine may provide an alternative. Go ahead.
there is a review every single year. The judge reviews this every single year. And every 3, in each case,
And the judge is presented with the fact that we didn't consider psychotropics.
First of all, it's an adversary hearing every single year. There's appointed counsel. Counsel can retain an expert. More importantly, for present purposes, DDS has the absolute right to intervene. In fact,
But let me confront just the facts for a second. Finding 201, peak GED applications for some JR students occurred in the 7th, 9th, 10th, or even 12th year. And I take it, when we look at other findings, we know that there's been no look back at drugs for 5 or 10 years. I mean, I can't make the linkage, but so
Your
for.
Honor, the peak, if there's a peak, it doesn't mean that this is what it was consistently the case.
Well, but it means that
It can be a
means
regression.
but it
There can be
means
a relapse.
Can I ask you a question on your fact number 2? You said that this is a remedy of last resort or treatment of last resort, and obviously the regulations and the consent decree say that there needs to be danger to self or others, right? There's evidence in the record that the treatments were given when someone reached for a tablet and some other problematic behavior that didn't rise to the level of self-injurious or harm to another. What do we do with that finding? And the judge makes no findings about this whatsoever, which is troubling. So what do we do with those facts?
This is referring to what the videos that, well, first of all, in some cases they're wrong. In some cases they haven't paid attention to the antecedent. And what JRC does and what the ABA method is to look at the antecedents and what leads to a certain problematic behavior, and you go after the antecedent. But that's true about some, and some of them are just when the staff misfired. The staff did wrong in those cases. That doesn't go to the treatment itself. Essentially what they did is they cherry-picked among hundreds, if not thousands, of videos, and they came up with these. JRC videos every single application of this in order to be able to monitor them and correct problems when they come up.
Was it a problem that the judge didn't confront these incidences in her report?
I imagine that she thought it wasn't a critical fact here because it didn't go directly to the treatment itself.
What goes to whether or not the
But I
treatment's being
can't-
applied appropriately, right?
Pardon me?
It goes to whether or not the treatment's being applied appropriately.
Well, it can happen that it's not applied appropriately in a given case. That can happen with any treatment. But that doesn't say anything about the general application of this particular treatment.
And
If I
counsel,
can get,
yeah, no, go ahead. You
I just
finish.
want to get back to Judge Kafka's issue, because what I didn't finish saying is that when this consent decree was originally issued, DDS was required to evaluate every single case and make a recommendation to the court. It came back to the court and it said, we don't want to be required to do that anymore. We want it to be discretionary. And ever since then, it has just opted out.
But
And then it has.
And I get that.
If I could just finish this.
Yeah, go ahead, sorry.
And then it has the right to intervene in every case, both at the beginning and in the yearly reviews. And furthermore, it has independent psychiatrists, psychologists, which it retains to make a thorough review of each case in every 3 years.
I get that they may be sleeping on their rights.
But they have a right to intervene and say, this particular patient should
I get
be
that.
tried on such and such a drug.
I'm trying to work, though, from the judge's fact-finding. Can you help me for, again, another fact? To me, I'm reading conclusion. This one really particularly concerns me. She goes, notwithstanding the above data, I'm reading from page 49, notwithstanding the above data and testimony, physical aversive treatment has not been effective for all JRC students and may not be the least restrictive procedure available to treat every student receiving physical aversive treatment. Isn't that a finding saying that students are getting shocked who shouldn't be getting shocked? Isn't she saying that? And
I think what she's saying, or what she's acknowledging, is that what this regime provides is individualized medicine, that there is no particular therapy that works for everyone. Certainly true that the drugs don't work for everyone and that PBS don't work for everyone and don't in particular work for the hardest cases. All of the experts, all of DDS's
but again-
witnesses admitted that.
But again, we've got a limited set of critical findings. And we also have to decide whether you're complying with the consent decree. And there are a lot of changes from when the consent decree, I mean, GED 4 is 3 times the charge of GED 1 or whatever it is, right? GED 4 didn't even exist at the time of the consent decree. Now GED 4 is the primary level 3 aversive, right?
I don't know, is that so? It is.
I think it's exclusive, right? Based on, again, I'm reading old facts and I don't know what's going on in the.
Don't recall what the numbers are, but both are used. I know that.
Both the yes, the GED
3
1 and
4
3 are used.
on different patients.
I get it, but isn't she saying that they're using this on people who shouldn't be getting it? If that's the case, is there some fact-finding issues that we've got issues with, that you may be violating the consent decree if it's based on her own findings?
What she also says is that there was no the DDS didn't do any kind of a particularized focus on individual clients. They just dealt with it as an abstract matter,
Right.
as a one-size-fits-all matter. And what she's saying
Right,
is
but
that
both sides are guilty of that, right? The center's philosophy is not to, and I'm not saying either one is right or wrong, but the center's philosophy is we want to get people off drugs and we want to use this shock treatment as a physical aversive, again, for this group of people who are self-inflicting injury and nothing else has worked. They're on the opposite end saying, we don't like this treatment, we want to eliminate it altogether. That's why we're here and you can't resolve this.
the latter is the case. But representing
Both sides, that's true. Isn't that true?
Representing my clients, who are the parents and the patients.
Right.
And our parents, who, believe me, are not, these are very committed, very informed,
This is terribly
very
difficult.
intelligent people. I have a two-time winner of the Pulitzer Prize. I have a Harvard professor. I have a doctor. These are all persons.
No one is suggesting your clients are not acting,
But what I want, I'm sorry.
but we've got problems in the other. We have to decide whether they're acting in bad faith and whether there are a limited number of questions. And my problem is I don't know how to resolve them based on this fact finding. Let me just tell you the 3 questions that are really striking me. One is is there a scientific consensus? Because if there is now, is there a scientific consensus in 2013? Is there one now? You're, I take it, saying that the judge got that one right. He is saying the exact opposite. We're going to have to go through that. The second one is bad faith. Here I'm more troubled, and I'd like you to help me out. The last act of bad faith by DDS is 2010. How do we decide that DDS is acting in bad faith when it's 13 years later, and actually, even during the time period the judge is evaluating, the 2000 certification process, they certify the center, they give it a 1-year certification, right? There's nothing improper about 2013. So is this bad faith finding stale and meaningless, particularly in 2023?
Well, it's taken this time to get here. Once there was a decision by the court, the DDS filed a notice of appeal, and I don't think
counsel,
they...
it could never get any better, could it? Because you can't do a long-term study. You can't take your patients one by one and try it just to see what would happen, because that's detrimental to them. So there's no evidence that was developed, and I don't understand what evidence could be developed that would show there's something better.
Well, I certainly think there is none, and we're aware of none, and the DDS has not produced any that we're aware of. So I don't know how else we deal with it.
Counsel, can I ask you a slightly different question away from the facts? When is it that a separation of powers trigger occurs? When we have a judicial branch oversight over the treatment received by individual patients? When does that, because this has been going on since '87, is the decree entered?
Right.
Is that right?
Well, first of all,
So I guess I'm wondering, when do we have to stop?
All right, there are two questions, I think. One is separation of powers, and the other one is, when is this over, right? I think as far as separation of powers, that issue was raised and resolved by this court in the contempt case back in 1995.
Right, but I guess my question is, at some point, we reach a point where that becomes a problem. And I'm wondering when. Are you saying never?
It reaches a point
So long as the decree is necessary, it's never a problem.
When the conditions for terminating a consent decree are found, which are a substantial change of circumstances warranting termination of the decree, which could be, one, that DDS no longer insists that this treatment not be used. That could be one change of circumstance. Or there could be some new scientific development that really does come up with a miracle drug that doesn't have these awful side effects and so forth. That could be a change of circumstance. And believe me, as far as my clients are concerned, if there was such a miracle drug, they would be happy to advocate it. And if there is one, indeed, that is exactly what the consent decree process is for. DDS should come forward and say, there is such a drug. This particular patient should get it. And a judge could then consider it.
Attorney Sterner, you had started by saying you said you had 5 points, and I think you got to 2.
Well, number one was nothing else has worked. Number one was nothing else has worked. Number two is this particular one has worked. Again, for this tiny endangered population. The third is there hasn't been any evidence of significant harm to anyone. Yes, indeed, there is pain. There is a 2-second transient pain. That's it. But and the judge did make findings about that. There was no evidence of any substantial or lasting harm. Fourth, as far as standard of care and the acceptance in the community, DDS's own psychologist testified that you need to have this as a last resort. Dr. Mickelson, not Dr. Mickelson, I'm sorry, Dr. Lewandowski, who was the chair of the certification team.
One question I had
said
on that, did he say that you need adversives or that you need this electric shock treatment?
Well, everything was focused on electric shock. This whole case was dealing with electric shock. And so people referred to physical aversives as well, but they were all talking at all times about electric shock. So there was Dr. Lewandowski. There was of course, the independent psychologist who DDS retained to do these 3-year reviews. They testified. There were remarkably, the members of the so-called PBS committee, which were assembled and informed about the change in the regulation after it had been decided to seek this regulation, these psychologists all said, you need to have this as a last resort.
So when we
And
look
what's
at,
your fifth point?
Yes, thank you.
And fifth was the rigorous vetting process that starts at the beginning, starts with the consent of the parents, starts with everything else, and then goes on in a yearly basis. And JRC has no excuse for asking this court to decide this as a one-size-fits-all, rather than coming into court in an individual case and making its case then. They did it once in the last almost 30 years, once.
You mean DDS?
Pardon me?
You said JRC. You mean
With
DD
JRC, yes.
Yeah.
And they prevailed in that case. Other than that, there are thousands of hearings every year in Rogers decisions with developmentally disabled and other developmentally disabled persons in their care, so-called Rogers hearings, in which the issue is whether they shall be prescribed psychotropic drugs. A DDS participates in every single one of these. And if they can do all those, why can't they do less than 60 people at JRC?
in the absence of a consent decree, it would be within their power probably to do this, right? It's the consent decree. They want to eliminate the practice altogether. And the reason they
I
lost...
actually don't think so. I think that's actually beside the point here, because there is a consent decree and they haven't shown the conditions for terminating it. However, the fundamental law of Massachusetts has always been, which is that any person has a right to have, to accept, or to decline therapy as long as it's prescribed by a licensed healthcare practitioner.
That's one of the things I'm confused a little bit about. If the legislature banned this, this couldn't be done, right?
Yeah. Yes.
And if there's the medical community itself, I guess can't eliminate certain treatments. It can. So the regulators and the legislature and the federal government are the three people who are able to ban things in total, right?
The legislature passes the laws, and it could do that, but it hasn't done it. Bills have been sent. Numerous bills have been filed in the legislature to do that. It has not made it unlawful, nor has it given authority to JRC to do it. So JRC has no more power to dictate what treatments can be used for this population than the Board of Registration in Medicine has a right to tell Mass General Hospital what kind of surgical procedures its surgeons can use.
Just for the record, I want to make sure you're saying DDS doesn't have the right. You said JRC doesn't have.
I'm sorry.
Yep,
You're-
I just
you're
want to
right.
make sure the record's clear.
DDS doesn't have, DDS doesn't have the fundamental power it claims to have.
So if there wasn't a consent decree, DDS could not pass this regulation saying that, because they pass regulations governing certain, I mean, they have no ability to pass a regulation banning a treatment protocol, is that right? So is that what you're saying?
Wind the clock back to how this all started.
Yeah.
Was when they first approved JRC, it was then called BRI, to use this therapy. And then they suddenly turned around and said, no, you can't do it, and they issued an order that
Can you just
can't
answer
do it.
the more basic question? Does DDS have the authority to ban, forget about, I understand the consent decree, bad faith, all kind, you can lose your regulatory power by acting in bad faith. But absent bad faith, absent a consent decree, could DDS do this legally? Could they say, this is a practice we do not tolerate to?
No.
Okay.
I mean, originally, that's what they did, and that's why they were enjoined, and it went up to the appeals court, and it was affirmed, and that's when they entered the consent decree.
So everything they're trying to do, in your view, is beyond their authority. Forget about the
They could
consent
be
decree.
given the authority by the legislature, you know, to do that, but they haven't been.
So they, I mean, the
So this
they
is
they are empowered to act by the legislature in various ways. I take it when we read their empowerment provisions, it doesn't give them the ability to ban a particular practice of medicine.
Right. There is a statute.
You agree that they have the authority to limit the practice to the injurious and self-injurious, right? You agree they have the ability to restrict the practice, level 3 aversives, right?
Well,
They have the regulatory authority to say level 3 aversives are only used in these criteria, correct?
that has certainly not been contested on our side.
Okay, I'll take that as a yes then.
Okay,
All right,
thank you.
unless there are any other questions.
Okay, Attorney Flammy, are you going to talk about something different, a different aspect? of
No,
this?
I made some notes. First of all, good morning, Justices. I represent the Judge Rotenberg Center. I made some notes about some issues that came up, which I think I can add some clarification on. Number one, there was a question about the GE3 device, the GED4 device. The GED4 device is used on very few clients. It's mostly the GED device, which is the lower level. It's confusing in the record because it's called the GED3, only because some modifications were made to the device, some safety features were added after the original design, and you have to come up with another name.
It's triple the shock, though, right?
Not GED,
Okay,
not GED3.
I
That's the
thought one is
same.
a .15.
GED4, yes. You go from 15 milliamperes to 45.
So is that a change in circumstances itself, that you're using a device that's 3 times as powerful?
No, there were many programs and clinicians using skin shock device. JRC did not develop anywhere near the first one. The first, there was the Sabre 6, there was the Cybus that was developed at Johns Hopkins. So the use of skin shock, and our opponents referenced that in their brief, was already in use in many programs and with many people. So this was not a new development.
Well, but it wasn't in place when the consent decree entered, we had no electric shock at all.
No, but
And then we went from GED to GED4/3, which is 3 times as powerful.
Your Honor, I wouldn't phrase it that way. The GED is what most of the clients get. A few clients get GED4, but what JRC was using at the
Can I
time.
ask where in the fact finding we can make, how do we find that in the facts? Because I don't remember that. Is that in the fact finding by the
I'm
judge?
sure we can send your,
No, again, we have fact finding, you know, if you guys don't.
oh,
wanna
in the
focus-
judge's fact finding. I don't recall, Judge, I can look at that.
Yeah, okay, we can figure it out ourselves.
And it is in the record. But at the time of the consent decree, JRC was using, and the court was approving spatula spank, which was this huge item with a sort of a rubber end and a big log handle, and they were spanking the clients with it. And that was much inferior to Skin Shark because you can't control how the staff does it, how hard they do it. Skin Shark was a much better device to use to apply an aversive consequence. DDS, this case evolves around a civil rights lawsuit that was filed by the parents because OFC had taken away this treatment. And OFC decided to settle that case and actually sought a release from the class for her conduct. So this is about people's civil rights, and the stakes couldn't be higher. This is about clients that can kill themselves and have killed themselves, fortunately not at JRC, but in other programs, because of the severity of these behaviors. So when we talk about people's rights, we're talking about life or death. The parties, Your Honors, did agree to the indefinite extension of the consent decree that was asked. And in fact, a few years after the consent decree,
When did they agree to the indefinite extension?
so there was a 6-month review,
Yes.
and then there was another 6-month review, so that's a year after. And at that time, Judge Rotenberg said, I'm going to extend this indefinitely, and nobody objected to it.
Okay.
Well, did they sign a document? I mean, the judge tells you I'm going to do something, and you sit there. They may not have objected, but did they, was this a, I mean, I'm not sure that constitutes consent when the judge is sort of saying, I'm doing this. They didn't object is what happened. Is that right?
I believe so, Your Honor.
Okay.
Now, but interestingly enough, at the request of DDS, the consent decree was amended a few years later. It was amended because one of the obligations DDS had was to provide these independent clinicians to evaluate the clients. And there was a requirement that that happen in every case as soon as JRC got a new.
Right, and they wanted it to be discretionary.
They wanted to be, yes, I'm sorry, Your Honor, at their discretion.
Right.
So this was an active consent decree. This was not something that everybody was standing around waiting to end after a year. It was ongoing. There are a number of studies.
Was that the last amendment to the consent decree, the last time it was revisited?
The only other time it might have been amended, I'm not sure, Your Honor, is when OFC actually came back into the picture, which is now called EEC, to start licensing again JRC's group homes for folks under 22. I'm not sure if it was amended or not at that time. Your Honor, in terms of the argument that there's a structural problem here because the judge set the bar too high to prove that this is allegedly no longer part of the standard of care, it was DDS's own expert, trial expert, Phil Lewandowski, the longtime chairman of the certification team, that said this treatment is needed. It's part of the standard of care. It is helping the patients at JRC. They'd be harmed if they didn't get it. The JRC is providing excellent care. The staff is well trained. The treatment is high quality, excellent data collection, excellent documentation. So there was, and then there was Dr. Bacardi, the recently retired DDS clinician who sat on JRC's peer review committee and
Reconcile all that with DDS's view that this is the only place and this is a complete outlier. How
Yes,
do you reconcile that testimony with their position?
Yes. It was one of the national experts, could have been Dr. Fox, I can't remember, who was interviewed by Dr. Hamad at UMass Medical Center when he was asked to look into this, who said, yes, you need level 3, you need it for these severe behaviors, but it's such a small, thank God, group of people that have this problem. You could probably have one institution in the country using it, and that'll be enough. So fortunately, very few people have this problem. JRC receives clients from all over the nation for this problem. And also, having represented JRC for 33 years, I can tell you it takes a lot of courage and a lot of conviction and a lot of strength to make this treatment available for people where nothing else works, because you get hammered in the press, you have to deal with government bad faith. But JRC's sole mission is to be there for the clients that have been treated in many of the great treatment institutions in this country, including treatment hospitals, and nothing else works. And on the issue of drugs, Your Honor, JRC has psychiatrists, it has a whole bevy of experts.
So those fact-finding, because again, we're not dealing in the abstract. We're dealing with, she's made findings that for 5 or 10 years, there's been no, drug review, essentially. She also makes that finding I read to Mr. Stern about that some of these people are getting treatment who shouldn't be getting it because it's not the least restrictive, right? She makes those findings. What do we do with that?
Your Honor, there are substituted judgment proceedings, as Mr. Stern mentioned. There's hearings every year. I would love to see.
Just tell me how because again, we've got fact finding that raises some questions whether some people are again, the consent decree says don't do this unless it's the least restrictive. The judge recognizes that, but she also says that some people are getting it who shouldn't be, right? I didn't misinterpret that sentence, right?
Your Honor, in my view, it was more of a concern than a finding that is happening. And how could that finding overturn the finding of whatever probate judge in Massachusetts has approved that treatment?
Well, probate judge gets one look at this in the beginning of the process. I take it these people aren't brought
But
back.
is that
every
true?
year, Your
Isn't
Honor.
it
Every year
annual?
they
Yeah,
go
it's an annual review. So
Yes.
there's one
Yeah.
hearing to start, and every year there's another hearing at which DDS is invited to attend.
Yes.
Okay.
Under this court's decision in the Whedon case, any treatment could be antipsychotic medication, which you have to get court approval for. Any of that treatment, extraordinary treatment, it gets initially approved by the judge, and it must be reviewed every year, or it cannot be used.
And that would include the ability to have a substitute treatment of psychotropic drugs, correct?
Yes, Your Honor. It would absolutely apply. I mean,
If they were to appear in those hearings and ask for that, and a judge would have to consider that.
yes, and then you have each client at JRC, just like the Rogers cases, the antipsychotic medication cases, has a court-appointed lawyer. And they can bring the case before the judge at any time. And JRC would love to sit down with DDS or any expert they have on any case where there's a feeling that a drug could work or something else would be least restrictive.
The question I have that I think other people have asked as well is, at what point does Article 30 weigh in here? And do we say that the department has forfeited its right to regulate this particular institution because of the decree? I mean, I get the findings of bad faith, so there's essentially a give and take where it says, well, you can regulate, but if you regulate in bad faith, you're out of the picture, and that's what we found in our contempt decision. But that's an older decision. At some point, do they get to regulate this institution?
If DDS could, in my view, resist the need to engage in bad faith. I mean, you think about the 2011 ban that they promulgated. It's pretty clear it's very clear in the record. They never did any research to support that. It was right after the 2010 bad faith. They never reached out to any JRC parent or family or any clinician. Hey, we're thinking about banning this. We know it's used at JRC. Why do you feel it should continue? Didn't do any of that. And Commissioner Howe was writing comments for the advocates.
But isn't that part of their rulemaking authority where suppose they have a rule that restricts severely level 3 adversives, they have to send it out for notice, they have to have hearings, and then you can be heard. How come that process can't be in this case?
Because DDS has proven over and over again that banning this treatment or stopping it is the product not of medical evidence, but of bad faith, because DDS cannot say to the anti-aversive advocates, this is a small population of folks, they need it, their parents have tried everything else, it's court approved, they can't do, they start to engage in this bad faith behavior. Like,
Can I ask you to help me out on this? Do I have any reason to be concerned that what's being analyzed is a standard of care of many years ago, maybe 7, 8 years ago, and My concern is, what is the standard of care today for these patients? And we're trying to reconcile, and we're trying to address a really difficult issue of these patients that need to have some hope, that their parents love them to death. On the other hand, we're worried about whether or not the treatment is just outside of the standard of care. And to me, whether it was within the standard of care in 2016 is not really something that I'm going to lose sleep over. I'm more concerned about the here and now.
The ambulances, sadly, Your Honor, still pull up to JRC with a client from some teaching hospital or another great institution with the person in 4-point restraint on massive amounts of medication because I can't stop the behavior. Those ambulances are still coming to JRC, and these people have blinded themselves. They have gouged out their eyes. I understand the court's concern, but the parents' concerns are even greater. JRC's concerns are even greater. In the moment there's a treatment that would be as effective or close to as effective, less intrusive, it will be used before this court or the probate court even has a chance to consider it. The parents will do it.
But just to be clear, if somebody pulls up in an ambulance to JRC in 4-point restraints, they are not going to get the